disperse it to Brian and Tony. What did they do? They just totally disregarded that order and started cutting checks, a check cutting party on May 14th. No court permission. You know, if I'm going to deviate from the order you signed from the disbursement sheet, I better come back before Your Honor and do that. No permission from the court was done. Nothing. No communication with these clients. This young man here, who's a vulnerable adult, who's in his 30s, lost his mother. Alex Murdaugh and Corey Fleming knew that his trailer was being foreclosed on, and he didn't have the money, and they're sitting on $4.3 million of their money while he's getting pushed out on the street and loses his mother's trailer. That was all she had. That was all she had. What happens? He keeps money in his trust account. Judge Mullen signed an order that said, you disperse every single penny in your trust account. As Mr. Woodard said, he kept it for 18 months in a case that was over with. In a case that he went before Judge Mullen and said in May, I need $105,000 of additional expenses that we spent. That's going to be dispersed. Again, in a case that no lawsuit, no depositions, no expert witnesses, and it was $105,000, not $105,172.27. It was just blatant thievery in open eyes of everybody except the two most important people that we work for, the clients. And what happens? Like Mr. Woodard said, on October 12th of 2020, 17 months later, they decide we're going to cut some more checks. And you know what? We better get this case off the docket. So Mr. Fleming and Mr. Murdaugh decide to sign a stipulation of dismissal. Mr. Murdaugh had a lawyer, John Grantland, who represented an Nautilus insurance company. He wasn't contacted. Mr. Fleming knew that there was a lawyer involved, and they dismissed the case. Yet he sits on another $113,000 for another year, all the way up to the fall of 21, when he finally was caught, when I finally surfaced on September 7th with my partner, Ronnie Richter. Now, I will say this. Of all the defendants that we got money for, and we can announce that we've recovered more than $7.5 billion for the Satterfields from a number of sources. Mr. Fleming was the first to come forward in the fall of 21. He did disgorge himself of the $680,000. His insurance company did pay the full value of his policy. He did finally disperse the remaining $113,000 in his trust account to my clients, and there was additional monies paid by his law firm. But the last thing I want to add, Your Honor, is he fought these charges. He wrote a letter to the Georgia Bar. Now, unlike our South Carolina bar proceedings, the Georgia bar proceedings are over. I was a complaining party because whenever I bring a claim against a lawyer for malfeasance or theft, it's my duty to notify the bar, and so I notified South Carolina Bar and notified Georgia Bar. So I'm part of the process in Georgia. They want to hear from the complaining party. So when Mr. Fleming filed his response to the Georgia Bar complaint, I got it. It was a 57-page response that he did under oath. Swore to tell the truth, just like he's going to do when he stands before you today. You know what he told the Georgia Bar? I was a victim of Alex Murdaugh's theft. I had no idea what he was doing. I was duped just like everybody else. I didn't understand how to do the structure of Forge. Mr. Woodard shared with you that February 2017 letter. It was crystal clear. And he had already done structures, but even if you haven't done structures, it says you can never get the check as the settling plaintiff lawyer. It's got to go from the paying insurance company to the annuity insurance company that's going to issue the structure. He already got the checks. Like Mr. Woodard said, Forge doesn't get money. They're a broker. You don't send money to forge. It goes to an insurance company. But in that 57-page response, he says, I had no idea what was going on. He didn't, you know what he said? I stole from my law partners. I didn't steal from the clients. When I stole those 3 checks of the $9,500, the $8,500, and the $9,000, I was stealing from my law partners. By the way, Judge, you read the rules of professional conduct. We don't have a license to steal from our law partners either. That's another no-no. So, I know you're a just judge. I've watched you your entire career. I know how much you care about what our profession. I certainly know how much you care about our state. And this whole Murdaugh, Fleming, Lafitte debacle has stained our state. And I'm going to leave with saying one thing. The hand of one is the hand of all. And Mr. Fleming is pleading guilty to every single charge, which means every single element of every single crime and every single fact that Mr. Waters has announced form the basis of those. So I ask you to do your duty, to look at this as these are state court independent charges, not to look at, well, he's been sentenced in federal court, so that kind of takes care of it. These are claims that our citizens, the state of South Carolina, brought through a grand jury, advanced with our dollars through the South Carolina Attorney General. And I'm confident that at the end, you will give that proportionate, just sentence that deals with retribution to punish Mr. Fleming appropriately, but not overly so. Deterrence to tell me and every other lawyer, you cannot steal from your clients. Your duties are to your clients, not to yourself. Thank you.
Thank you.
Your Honor, I think our final victim presentation before I conclude my initial remarks comes from Mr. Bamberg, who again represents Pamela Pinckney. And I think it's important to point out that while there has been a resolution in federal court, that was only on indicted Satterfield conduct because of the statute of limitations there. And I know that Mr. Bamberg will address, of course, that we are here today for the first time for accountability as it relates to Ms. Pinckney alone. And Mr. Bamberg, I'll turn it over to you.
Thank you, Your Honor.
Yes, sir.
Creighton is correct, Attorney Waters is correct. On behalf of Ms. Pinckney, she wanted to be here, but she had a procedure on Monday, a medical procedure, and she's been dealing with a lot of pain since. So I'm here on her behalf, and that really speaks to the type of people who were victimized. We had to sit through a federal case through the United States of America's court system and hear about things that were done to the Satterfields. And Ms. Pinckney, her family supports the Satterfields. What happened to Ms. Pinckney, what Mr. Fleming did to Ms. Pinckney was mentioned in the federal case. However, due to statute of limitations, she was not able to seek justice, criminal justice through that. That's what today is for. It's her first opportunity after well over a decade. Your Honor, I want you to understand a little bit about what Ms. Pinckney went through. When we think about white-collar crime, a lot of times people talk about it as though it is victim bliss, that it just involves the almighty dollar, and that's not the case. This was a horrendous accident. Not only did Ms. Pinckney shatter most of the bones in her body, there was a very extensive recovery process for her. But she had to deal with injuries to other people that she cared about. For example, her niece, who in addition to numerous physical injuries, lost the vision of one of her eyes. And her son, Hakeem Pinckney. And Hakeem, Ms. Pinckney poured her soul into that young man. And he lost his hearing at 3 years old. He struggled with that. And she never gave up on him. She poured into him. He ended up graduating from the South Carolina School for the Deaf and Blind. And shortly after graduating, he had all these dreams and ambitions. And during that accident, that fateful day, this young man was rendered a quadriplegic. He was unable to move anything. below his neck. He was on a ventilator to breathe from him. He relied on an electric machine to breathe from him. And because he couldn't move, he couldn't sign language, and therefore he could not verbally communicate. And she never gave up on him. Hakeem died, and it was very tragic. His ventilator was found unplugged. So, you know, and it's hard not to get teary-eyed when you think about what he went through, but here's a young man who cannot hear, he cannot speak, he cannot move, and now he cannot breathe, and he can't tell anybody. He became a prisoner of his own body. And Miss Pinckney was aware that that is how her son died. And instead of being a supportive lawyer, instead of showing compassion and care, empathy or sympathy, he could have said to this woman, I am so sorry for what you went through. I want to own up to the fact that I took some of your money. No, he didn't. In fact, they took the money and they flew to the College World Series to watch baseball. Meanwhile, this woman is still recovering. She's still dealing with the loss of her son. And no one cared. And I've said this before, Miss Pinckney, myself, the Pinckney family, everyone believes that Mr. Fleming regrets everything that he did, not just to them, but to the Satterfield family over a decade later. Nobody doubts that he regrets it. It's hard to not regret your decisions when you're sitting there. I think everybody regrets that except complete sociopaths. We do not believe that he is remorseful for what he did, and there is a difference between I regret getting caught and getting in trouble and true remorse for what I did to you. When we hear these numbers, Your Honor, and we hear numbers like $500,000, we hear numbers like $3 million, we hear about total amount of money stolen, we have to remember that where we come from, and myself, Ms. Pinckney, that I'm talking about geographically, where we live, we're $8,000 check, $9,600 check. Yes, for privileged attorneys and others who either have been very blessed, very successful, or work very hard to get there, it may not sound like a lot of money when you hear about $4 million get taken. Minimum wage in our state, Your Honor, $15,850 if you're making minimum wage. That's how much you earn working for a year. Some of the money that Ms. Pinckney lost, she would have to work over half a year to earn and then pay taxes on it. This is not a small amount of money. This is not a victimless crime. Your Honor, we trust the system. And I echo much of what Eric Bland said, that this was a black eye to attorneys. It was a black eye to the legal profession. It was a black eye to our state. But it was a dagger in the heart of the clients who trusted their lawyers. Mr. Fleming knew he wasn't supposed to do it. We firmly believe, and I've had in-depth conversations with Ms. Pinckney about this, it wasn't until the federal government came, and now there was this window of opportunity to possibly serve a sentence in federal court, that Mr. Fleming was then willing to say, yes, I did X, Y, Z. Up to that, there was no, yes, Ms. Pinckney, I took your money. That wasn't represented to the ODC ethics, as you heard Attorney Bland reference. It was deny, deny, deny. And one of the most difficult things for Ms. Pinckney and every other victim is having to know that you are truly a victim of bad acts from bad actors, and then hear those same bad actors who took bad acts say that they're a victim. It's demeaning, it reopens old wounds, and it's highly offensive. And in the world of white-collar crime, Your Honor, if we talk about Wall Street, it's not necessarily people stealing your money and you willingly give it to the investment bankers. No one willingly gave Corey Fleming their money. He deceived them. He took it. You know, and I know that there will be folks who will speak very positively about him. And we have no doubts that to a lot of people in his life and over the course of his life, Your Honor, he was an amazing person to them. He did do wonderful things to them. He was very giving to them. But he's not here today sitting in judgment of Your Honor for how good he was to everyone else. He's sitting in judgment for pleading guilty, element for element, charge for charge, to how bad he was to Miss Pinckney and the Satterfields. And we would ask that, Your Honor, take all of that into consideration. This is their one chance after over a decade to get justice, Your Honor. And we ask that this court impose a sentence that is not only sufficient to, again, punish Corey Fleming. He's got a federal sentence again, but has nothing to do with Miss Pinckney. He has not been punished for that. We ask that you sentence firmly to not only punish him for that, but to also deter not just lawyers, but anybody who owes a fiduciary duty and people rely on you. Don't steal from them. We're not expecting people to be perfect, but we are expecting you to be a decent human being. And if you're a lawyer and you take that oath that we all have to take, that you take that oath seriously. And it doesn't matter whether you personally have hard financial times or not. The saddest part, as an attorney who's gotten to know Miss Pinckney, Your Honor, is knowing that even with the horrible death of her son, even with her own broken bones, her own medical bills, is that Corey Fleming needed money, Your Honor, and asked her. I guarantee you she would have gave it to him. That is the type of person Miss Pinckney is, and that is who he victimized, Your Honor. Thank you so much for your time.
Thank you.
Your Honor, I just have a few more brief comments, and then I will yield to the defense for their presentation. Again, would request the opportunity to speak and reply after they have presented. Mr. Bamberg touched on this, and I know Your Honor has been presented a lot of letters, and I know that there's support out in the courtroom for people who have known Mr. Fleming, and I'm sorry. I'm sorry to them because they've been victimized by this too, because they have to be here. And they're put in this position. And I'm sorry that they have to go through this because I have a job to do. These people on our team have a job to do. The law enforcement officers here have a job to do. And the reality is that to be a con man, it depends on trust. It depends on reputation. It depends on the inherent credibility that comes with having a law license on your wall. It doesn't work otherwise. It depends on someone who doesn't have a prior record, which Mr. Fleming does. That's how con men work. That inherent trust and reputation is what they tread upon for this scheme. It doesn't work without all these good things that people are going to say that they believed about Mr. Fleming. It's the only way a con man can succeed, is if people trust him. And they did. And he betrayed them. You might hear a little bit about the process, and you may hear essentially that the state, the Attorney General, the State Law Enforcement Division are being unreasonable because we refuse to accept and just check the box that Mr. Fleming was only doing 58. Instead, insisting, because of the hard work that was done by all these folks, to really dig deep and uncover the truth The truth matters, Your Honor. The truth about what happened to the system matters. The fact that he was doing 90 miles an hour matters. It matters. It's not enough to just say, I did 58, and we say, okay, that's fine, we're done here. What really happened matters. When it affects the integrity of the system, when it was abuse of the system, of the very courtroom in which we are in right now. Your Honor, independent accountability for his abuse of his state law license and state court actions is warranted in this case. Consecutive time is warranted. Consecutive time is warranted for the extent of the reality Mr. Fleming did to the Satterfields, exposed in this courtroom, the 90 miles an hour. Independent accountability is warranted for that, above and beyond whatever was before. I'll give Mr. Fleming credit for pleading guilty, but he doesn't get credit for the delta, for the difference between 58 and 90 miles an hour. And his inability and refusal to admit to that, to only admitting to the most mitigating version of events that he can no longer deny because he's caught red-handed, that only should get so much credit, Your Honor, and there needs to be independent accountability for the truth of what happened to the Satterfields, above and beyond nothing to do with what happened here, or what this proceeding was. Independent accountability is warranted for Pamela Pinckney. Said has relating to the conduct victimizing her in this court. And while you may hear that in another proceeding they rolled that into a PSR, that's not the same thing, and we don't even get that. I don't know what's in that thing. It doesn't matter though. A lawyer should not get one-stop shopping for victimizing multiple clients of a decade. It's not buy one, get one free. There should be independent accountability here today, consecutive accountability for Ms. Pinckney. He should not get buy one, get one free. And independent accountability is again warranted for the state judicial system itself. They must defend itself and have its own independent accountability, and not allow someone, when the state is unhappy with 58 miles an hour, to just make a deal and that be the end of it. I ask Your Honor for consecutive sentencing. I ask Your Honor that even if you run sentencing for the Satterfields concurrent to anything else that happened, that any sentence for the Pinckneys be consecutive. I ask Your Honor not to let Mr. Fleming, who I think we have established has not completely come clean with the reality of his behavior and only admitted to what he's admitting to now because he got caught red-handed.
What is his exposure for in the Pinckney case and the Satterfield case?
Stand by, Your Honor. So the total exposure between the two is 195 years and fines up to over to $8,090,863.90 plus discretionary fines. Your Honor, if we look at the Satterfield crimes, count 10 is a criminal conspiracy, which is 0 to 5. We have 3 counts of insurance fraud, $50,000 or more, which is 0 to 10, plus fines of $20,000 to $100,000. Counts 13, 17, 21, and 30 are breach of trust with fraudulent intent, $10,000 or more, which are 0 to 10, plus fine in the discretion of the court. Counts 14, 18, and 22, value of money laundering, value $100,000 or more, carry a potential sentence of up to 20 years, Your Honor, and a fine not to exceed and/or a fine not to exceed $250,000. Counts 23, 25, and 27 are breach of trust with fraudulent intent, value $2,000 to $10,000. That's 0 to 5 plus fine in the discretion. Counts 24, 26, and 28, 3 counts of money laundering, value more, value $300 to $20,000, which is 0 to 5, and/or fine not to exceed $250,000 or twice the value of the transactions. And then count 29 is computer crime, value more than $10,000, which is a 0 to 5, and/or fine not more than $50,000. Your Honor, that is the Satterfield case. For the Pinckney case, 2022 GS 4702, again, both of these indicted by the state grand jury back in early 2022. We have counts 5 and 9, which are breach of trust with fraudulent intent, $2,000 to $10,000, which are 0 to 5 plus fine in the discretion, or fine in the discretion. Counts.
You say 0 to?
0 to 5 or fine in the discretion for that one, Your Honor. Count 6, breach of trust, 2,000 or less. That's actually a 30-day offense, Your Honor, or a fine not more than $1,000. That would have been one of the crosswind checks, which was like $1,400. Count 7, which is criminal conspiracy, that's 0 to 5. And count 8, breach of trust, 10,000 or more, which is 0 to 10 for fine in the discretion. Again, the state would submit that no matter how you stack them, even if you run certain ones together, that there needs to be independent consecutive accountability from one to the other. And that there needs at a minimum to be a lead sentence for the Satterfields and a consecutive lead sentence for the Pinckneys. So that Mr. Fleming, for decades, almost a decade's worth of conduct, doesn't get buy one, get one free. Thank you, Your Honor.
All right. Ms. Barbier?
Thank you, Your Honor. May it please the court.
Yes, ma'am.
Your Honor is aware that on August 21st, I filed with the court an initial sentencing memorandum, and in that sentencing memorandum laid out for Your Honor some of the background of the investigation, joint and federal investigation, and then also talked a lot about Mr. Fleming's life, his community involvement, the things that bring him to you today as a whole person to look at. And then, Your Honor, following the guilty plea, which is when we heard a lot of the same information that we heard today from Mr. Waters, on September 12th, we filed a supplemental sentencing memorandum. And in that sentencing memorandum, We addressed a few of the factual issues that we had some discrepancies with. And then yesterday, I received a response from the state. And I want to thank the state because they responded very quickly. And I think that what I gleaned from their memorandum is there's very little that we disagree with in terms of the responses they made to our sentencing memorandum. First, Your Honor, I took issue with the fact that they said that Mr. Fleming had invited Mr. Satterfield into his office and changed the personal representative execution forms. I pointed out the evidence simply doesn't support that, and Mr. Waters agrees with that. And we're not saying it's material to his guilt, but we wanted to point that out because it was factually inaccurate. Secondly, Your Honor, with respect to the caption that was created on the stipulation of dismissal, the petition and the order, that was not done by Mr. Fleming. Again, that's not material to his guilt, but it's something that, I wanted to point out for the court was not accurate. Regarding the check that was written on the Pinckney settlement proceeds, the $89,000 check, Mr. Waters stated during his plea factual basis that had been made out to Alec personally. It was not. It was made out to the Murdaugh firm at that time. Again, that's not necessarily material to his guilt, but that was a factual inaccuracy that we wanted to point out. Most importantly, Your Honor, and I appreciate the state's candidness with the court on this issue, they, right out of the gate in their sentencing memorandum said, and I'm quoting them because I don't want to misspeak on their behalf, they said the state does not allege that Fleming necessarily knew the specific particulars of Murdaugh's fake forge account or that Murdaugh intended to steal all of the money given to him. Indeed, the state has consistently accepted that Fleming might not have expected Murdaugh to steal all of the money. And that's an important fact to Mr. Fleming, Your Honor. That's an important fact that he wants you to know, and that, again, was reiterated today by Mr. Waters in his closing argument or his fact, whatever you want to call it, that he made today. And so we appreciate those two concessions. Those are very important for Mr. Fleming to have on the public record, both for him and for his friends and supporters to understand. And so I appreciate the state's response and the prompt response of that nature. With respect to the forge issue, Your Honor, I know that Mr. Bland and Mr. Waters have made a lot of comments about what Mr. Fleming definitely knew or should have known or did know and what he did. We pointed out in our sentencing memorandum a couple of things that I think would be good to reiterate at this time. Your Honor's heard, I'm sure, a lot about forge from the other trial that you had and from the information in that trial that was put forth about forge consulting. Your Honor's probably aware that the fake forge account was created in September of 2015, which is years before the Satterfield case came to be. The account was started at Bank of America, and it was titled Alexander Murdaugh DBA Forge. The account clearly had no affiliation with the real Forge Consulting. But Mr. Murdaugh was the only authorized signer on that account. He's the only one that had access to it. He's the only one on the signature card. And unbeknownst to Mr. Fleming and to a lot of other people that Your Honor himself heard from during that murder trial, good people, people that had known Mr. Murdaugh for 40 years. And the crux of the testimony, Your Honor, and I don't have to tell you because you had front seat to that trial. But the crux of that testimony was that Mr. Murdaugh habitually lied to everyone in his personal and professional life. He lied extensively to his law partners, to his accounting department, his CFO, his family, his office manager, his banks, his creditors, his opposing counsel, to judges, and court personnel. And Your Honor, during this time period, I think it should be known, Mr. Murdaugh was the president of the Trial Lawyers Association. He was a by many accounts, a respected member of the bar, and a lot of people, including Mr. Fleming, were stunned to find out that he had been stealing millions of dollars, diverting it into this fake forge account. Ms. Seconder, I recall, her testimony was that the firm had these checks being written to forge for years out of their trust account, and they didn't know he was stealing. There were the bank statements from the fake forge account were in Mr. Murdaugh's office. No one caught that. No one caught the fact that these checks were coming back with his individual signature on it. Mr. Fleming never saw those types of checks come through his office. I cited to the testimony of Mr. Cope, a partner at the Murdaugh firm, who recounted the story of when he told Mr. Fleming about this fake forge account and about what had transpired at the firm and about the fact that they had caught Mr. Murdaugh stealing money from the firm. And I cited to you, his testimony, and the crux of his testimony was that Mr. Fleming immediately brought up the Satterfield case. He was calling him about a completely different matter. Mr. Fleming's the one who brought up the Satterfield case and said, oh my God, we had the forge account in the Satterfield case and it was for millions. And Mr. Cope's clear impression was that Mr. Fleming was shell-shocked. And I say this, Your Honor, and I give you this information not to minimize or downplay or excuse any conduct of Mr. Fleming, okay? Because what we are here today for is a sentencing. As Your Honor knows, Mr. Fleming has pled guilty to each and every count that he's been charged with. That doesn't happen very often. He pled guilty to all of the conduct in federal court, and he's pled guilty in this court to the conduct. And so he's not here to make excuses for himself or to call himself a victim or to place the blame on anybody's shoulders other than his own. But I have to take issue with the theme of Mr. Waters' closing argument during this process here. He says that Mr. Fleming's guilty plea is the equivalent of pleading guilty to speeding at the rate of 58 miles an hour in a 55-mile zone when he's really going 90. And I have to say, with all due respect, this analogy is a gross mischaracterization of Mr. Fleming's guilty plea and the illegal conduct that he has fully acknowledged. He's pled guilty to each and every count in state and federal court, and that's a total of 24 felony counts. And that's hardly a speeding ticket. And he has not run away from his guilt in this case, not in any way whatsoever. He has, as Mr. Waters would have you believe, he's not run away. He has confronted his actions. He has stepped up to the plate. He has fully acknowledged that he was wrong, that he committed illegal acts, and that he is guilty. And he can only give this court and he can only give the government the facts as he knows them. That's it. He can't make things up about himself or other people. He can't say things that aren't true. He has acknowledged his guilt, though. And as Your Honor's aware, that is not the case in most cases. In most cases, first of all, people aren't always prosecuted in both state and federal court, even when there's concurrent jurisdiction. Many times one prosecuting entity defers to the other. That's generally the normal course of business. Your Honor was a prosecutor. I was a prosecutor. That happens all the time. And that's not the case here, and I'm not here to complain about that. And we're not here to complain, and we're not here to subscribe any kind of motive to those decisions. But what I do know is this. I know that the South Carolina Attorney General's Office and the United States Attorney's Office share the exact same goals. And the primary goals of those offices are, number one, to protect the public, and number two, to promote respect for the rule of law, and number three, to defer and deter future misconduct, and also, in the end, to ensure that a punishment that is sufficient but not greater than necessary is imposed. And I submit to Your Honor that all of these goals are accomplished in a concurrent sentence. No individual should be forced to serve 2 separate sentences for the exact same illegal conduct. And I want to address a matter that Mr. Bamberg and Mr. Waters have both raised regarding the Pinckney matter. The Pinckney matter was fully included in the state sentence, and Judge Gergel made that extremely clear. It was included in the loss calculations. They were notified under the Mandatory Victims Act. The loss amounts were included in the loss calculations. The restitution was ordered on the Pinckney case. Ms. Pinckney and Mr. Bamberg were available to speak at the sentencing. They attended all the hearings that I'm aware of, and they've been given treatment just as any other victim in federal court. So that matter has been heard, and it wasn't litigated because Mr. Fleming acknowledged his guilt in those matters. And so this idea that justice hasn't been served in that case, I find, I take issue with that because it has. I mean, you don't order restitution in a case unless there's findings made and unless they are considered victims in the case and unless that conduct was folded into the sentence created by Judge Gergel. And so, Your Honor, what I would submit is that the desire to pursue dual prosecutions it's within the discretion of these prosecuting bodies, but it also, that desire still has to be tempered by the rule of law. And justice, I would submit, is not served for South Carolinians or defendants by obtaining multiple convictions in a high-profile case and requiring a man to serve 2 separate sentences for the same offenses. And that, Your Honor, is consistent with the rule of law. I would submit, Your Honor, that, and there's been a lot of talk about this involves a state license and a state court system and state judges, and I don't disagree with any of that. Of course it does. I mean, that's why we're here, because Mr. Fleming has admitted guilt in that. But when you look to, who the United States Attorney's Office and the Attorney General's Office, who they serve the public. And it's not 2 separate publics, it is the public. And I don't even say it's to the citizens of South Carolina because they serve the non-citizens too. They serve everybody. And so I don't understand the division that's being tried to create here with respect to, justice can only be done here in this courtroom. Of course, this courtroom plays an integral role in serving justice. But Your Honor, I believe, understands that the role that these prosecutors have and the role that the other prosecutors have are the same. And they generally work as a team, and they generally work to the same ends, and that is to see justice served. If you look to the American Bar Association's standards on who the client of the prosecutor is, there's a section, and it's in a publication they put out called the Criminal Justice Standards for the Prosecution Function. And it says the client of the prosecutor is the public. And it's not any particular government agency, law enforcement officer, or unit, or witness, or victim. When investigating or prosecuting a criminal matter, the prosecutor does not represent law enforcement personnel who've worked on the matter, and such law enforcement personnel, they're not the prosecutor's clients. The client is the public for both prosecuting entities. So, Your Honor, I would submit that in these proceedings, those purposes are being served. And I don't take any issue with the representation that the Attorney General's office has made that they have been a central role in this case and that SLED's been a central role. I wouldn't dare to endeavor to do that, Your Honor. Everybody has an important role in this process, and certainly the Attorney General's office and SLED has too. And from my understanding, from all the press releases that have come out from both bodies, they have embraced the idea that this was a joint investigation and there were joint efforts by everybody involved, all the agencies involved, to bring this case to justice. And Your Honor, I would like to take some time to talk about Mr. Fleming and his life before this, his family, his community, many of whom are here today. You've got a packed courtroom. And I would submit, Your Honor, that doesn't happen every day. As Your Honor might be aware, I think that Mr. Fleming is overwhelmed, and he knows how lucky he is and how grateful he is to have the support of so many people. And contrary to what the comment Mr. Waters made, they're not here because they have to be. They're here because they want to be. They're here because, they understand that Mr. Fleming made some terrible decisions. They understand that this has forever changed the course of his life, but they are forgiving and they are supportive. And I think it's a beautiful thing to see, I believe. But, Your Honor, I want to take just a brief opportunity to introduce you to Mrs. Fleming. She's here. They've been married for 25 years. She's seated in the courtroom in the front room. His parents are also here. They're Caroline and Frank Koslick and Astor and Catherine Fleming.
Do you want them to stand so I'll know who you're talking about?
Sure. If you all would stand, I would appreciate it.
And who's standing?
So on the far right, we have Eve Fleming. Ms. Fleming's also a member of the bar. She's a public defender here in this area and has worked with juveniles her career. And then we have Mr. Fleming and his wife, Catherine. And then we've got Caroline and Frank Koslick, Mr. Fleming's mom and stepfather. And so, not only have these friends and supporters and this family been here today, they were here. A lot of them came to his guilty plea in Williamsburg County, and a lot of them came to his federal proceedings as well. So it's a very, I can tell you Mr. Fleming is overwhelmed with gratitude for that and doesn't necessarily believe that he's deserving of it, but is extremely grateful. Mr. Fleming also has 2 children. They are not here today. One's in college, and Mr. Fleming felt that it would be better for him to continue his studies and focus on school than he came to the federal plea, and so he's not leaving school to come to this. His daughter just started a job with the Department of Defense.
Do you want them to continue standing?
Oh, no, I'm sorry. I apologize. His daughter's not here today. She's overseas. She's just started a new job, just graduated from college. Mr. Fleming's very proud of her. They all are. She was at his federal plea. And so, I can tell you that the friends and supporters that he have, and we've talked about this in our sentencing memorandum, but I think that it sheds a lot of light on his unique personal history and characteristics, because this is his community and they're here for him. He's had some extraordinary good works. And so I want to take a few moments to talk about that, just to give you some additional insight. And I want to make sure, Your Honor, that I preface these comments by saying nothing that I'm going to say or that his supporters are going to say about him and about why we're here today is meant to diminish his acknowledgement of his guilt or his acknowledgement of the wrongfulness of what he did. Mr. Fleming acknowledges the seriousness of his actions. He feels nothing but remorse, and he has expressed that remorse on multiple occasions, but he specifically did it at the sentencing hearing in federal court, and he's going to do it again today, Your Honor. And I'm sorry that there are some that don't believe it's sincere remorse. I think, Your Honor can be the judge of that. I know that when Judge Gergel listened to his remarks and to the remarks of the people that spoke, he did believe that he was remorseful. And, it's going to be really hard for me to talk about Corey Fleming's life and do a better job of describing him than the people who have written you letters. And I know Your Honor has received a lot of letters. People are still writing me letters. As of yesterday, I was getting new letters. They keep coming in, Your Honor, and I think that's a testament to how strongly people feel about Mr. Fleming. And a lot of these people have a different story about how Mr. Fleming has made an impact on their lives, how he helped them, how he was there for them when they were in need. They're letters that are written by people from all walks of life. Some live in this Beaufort community, and some are from far away. And some are from our older citizens, and some are from very young adults. And some are from his peer group and his former colleagues. And these people aren't all people that know each other, but they all have stories about Mr. Fleming. And I would submit to you that there are a couple of common themes that run throughout these letters. The first observation that I had when I read these letters was that, it sort of was in keeping with the theory that I've had since I was a judicial law clerk, and that is that you can tell a lot about someone from how they treat the courthouse staff and the non-lawyers in our system. You've received a lot of letters from some of those people, and they talk about the Corey Fleming that they know, and those people include, a bailiff and somebody who worked in the clerk's office, people who have worked at the solicitor's office with him, a retired state trooper and a court security officer who said that there are not enough accolades in the English language to describe his personality and character. There are several letters from people who worked as his paralegal. There's a letter from an agent with the South Carolina Department of Probation and Parole who's known Mr. Fleming for 30 years. And she describes him as, quote, a wonderful human being. She says his character, his work ethic, and behavior over the course of our personal and professional relationship has been above reproach, and his dedication to serving the community and his clients has been inspiring to witness. And Your Honor, in addition to the courthouse, the letters that I have received from the court personnel, I've also gotten a chance to personally observe people who have interacted with Mr. Fleming when I have gone to court with him. And this is before he was in custody, obviously, and even after he's been in custody. But there have been just a number of people who've approached me and who've approached him to just say, that they were praying for him and that they were thinking of him and had nothing but good things to say about Mr. Fleming. And so what this tells me about Mr. Fleming is that, for decades, he has treated all of the people who play a unique and important role in our court system with the utmost respect, kindness, and professionalism. And the second theme that I see emerging from these letters is that, I think you can tell a lot about a lawyer from the way he treats young lawyers. And, there are a lot of letters that Your Honor has received from people who knew Mr. Fleming when they were a young lawyer. I remember being a young lawyer. It's scary. You don't know what you're doing. It's intimidating. But many of these people talk a great deal about how Mr. Fleming would step in and help. When they were first starting, he saw them in court. He understood they didn't know how to do something. He gave them guidance. He gave them advice. He helped them through a hearing. He was never too busy to assist and offer advice. They say when they needed something, they could stop by his office. And, he was never too busy. He would take the time to introduce them to people while he was at the courthouse or at a bar function. He made them feel welcome. They also talk about Mr. Fleming's selfless acts of kindness and helping people who were in the courtroom who didn't have a lawyer because they couldn't afford one, and he helped them anyway. And, Mr. Fleming wasn't writing down these hours to try to get pro bono, lawyer hours or become, known as a pro bono lawyer. He's doing it just simply to help people that needed help. Some of the letters talk about the fact that if the bar had a fundraiser, Mr. Fleming was the first to volunteer his time, to help. The letters describe Mr. Fleming as a lawyer who would stay involved in his clients' lives. He'd help them get jobs. He lent them a car, mentored their children. The list goes on. One letter notes that he's represented the families and the victims of violent crimes free of charge many times during his career, and that he would go above and beyond to help these people through that process for no compensation, only because he knew, and having had a wife who was a public defender, he knew, what that's like, what it means to be in that system. And I do want to quote one letter, Your Honor, from one member of the bar. He said, "I do believe at worst Corey is a good and decent man who succumbed to a very unfortunate lapse of judgment for which he has already paid very dearly." So, Your Honor, I would submit to you that all of the good things that Mr. Fleming did for the legal profession in South Carolina over 29 years, you must also take that into account when fashioning your sentence. And I know that, Your Honor has been sentencing people a long time. I know that it's probably a very difficult part of your job. And I know that you take genuine care in doing this. But when you sentence someone as a whole person. And when you look at Mr. Fleming's life outside of the practice of the law, there's another theme that runs through it, and that is service to his community, service to others. Some of these letters talk about Mr. Fleming and his life as a neighbor, his life as a landlord, someone they knew from the YMCA, who he was very active in getting built in this county. His church. And you look at what they say about Mr. Fleming. They say that he's the guy that comes over at the crack of dawn on Christmas morning when your pipes are broken. He's the guy that helps you move in on the day your moving truck pulls in and then brings you dinner. They talk about the guy that helped with home improvement projects and never asked for anything in return. He's the guy that made sure you had a ride home from the hospital after you had a stroke. These are all from the letters, Your Honor. He's the guy who cried with you when he discovered that your mom had Alzheimer's and then took the time to take your mom to lunch the next day to make sure he was spending some time with her. There's somebody that some of the letters talk about a man that Mr. Fleming discovered was homeless and how he helped him find a place to live and has helped him get work. The woman who cleaned his house for years talked about how he treated her like family and invited her and her family to share holidays with them. And so, Your Honor, the stories, they go on and on about the help that in the community that Mr. Fleming has served for so many years. One of the things that stands out to me are the single parents that Mr. Fleming has helped. I mean, they talk about the fact that, he did work around their house. He spent time with their children because they didn't have a father. One woman said, who was an 18-year-old single mother when she met the Flemings, said, "Corey, quote, changed the trajectory of my life, and he changed the trajectory of my 22-year-old daughter's life. He invited her to a play group, befriended her. He drove her daughter to school for 15 years, lent her a car when she needed it, invited them on fun outings, and made them feel like a part of the community." Another person that you're going to hear from today who was not at the federal sentencing but who has come a long way to be here today is Miss Blue. She was another single mother who rented a house from the Flemings, and she's going to talk about how she was treated by Mr. Fleming in particular. The fact that when she needed help, when she couldn't make ends meet, he was there for her and didn't require her to pay rent. Which she talked about when her son got in trouble, he was there for her son. So she's here today, and she's going to address the court. Some of the other letters talk about Mr. Fleming being like a parent to many of his children's friends. There's one couple, and their children's friends were in their early 20s, and I thought this letter was so insightful, written by somebody that young. And she said, "I wish that you know that Corey is so much more than this gross error of judgment. Corey is the type of person who treats strangers like friends and friends like family. I have witnessed countless examples of kindness and generosity towards others, organizations, and their families." So what I would submit to Your Honor, unlike the picture that Mr. Waters has painted for you, that Mr. Fleming was using his goodness for evil, what these letters reveal and what these people are going to tell you is that over his lifetime, Mr. Fleming has demonstrated the fundamental values that sustain a community. Another constant theme about Mr. Fleming is him as a father, him as a husband and as a son. And in every single one of the letters, because everybody that knows Mr. Fleming knows that his family is the most important thing in his life, his family and his faith. They all describe him as a devoted family person, loving, caring, present, and someone who sets an example for other peoples in the community about his treatment of his family and his parenting skills. And, you know, Your Honor, this is, I think, as Your Honor knows, all of these cases, and in every case, whether it's white collar or whether it's, you know, any kind of criminal case, it's always hard on the family. And, you know, I think that if there's any solace that Mr. Fleming takes in the decision that he's had to make here, which was to own up to his guilt, it is that he's demonstrating for his children what you do when you make a mistake. You know, you step up, you own it, and you admit you were wrong. And that's what he's done. And that's what he hopes his children gets out of this. Because what he has done is try to do everything human possibly to right the wrong here. You know, you've heard from Mr. Bland that he was the first person to step up and return every bit of the legal fee that his firm took in the Satterfield matter. He's been the first person in this matter to plead guilty, period, and to own up to what he's done.
That his firm took?
I'm sorry. No, I'm sorry, that was issued to his firm. The total fee, $672,000, went to Moskun and Fleming, and then it was split. So yes, that was all returned, Your Honor, in that case. But Mr. Fleming acknowledges his guilt, obviously, in the role he played in getting that fee. But Your Honor, he has stepped up, and this has been obviously a very challenging period in his life. The thing that his friends and his supporters and people know about him, though, is that they believe, and I believe, have faith, that he will learn and he will grow from this experience, and he will come out of this better and stronger. And that's the point of punishment. Part of that is rehabilitation, and I would submit to you, Your Honor, that that's already started occurring. When Mr. Fleming's law license was suspended, he didn't curl up in a ball and lie in bed, okay? He didn't, portray that he was bitter or angry at the world. What he did was started working for Habitat for Humanity. He's very skilled in construction, and he immediately began volunteering his time there because he thought it was the one thing that, he was determined to be productive and determined to be useful in his community and to do something that he could put his skills to work and help other people. And you've got a letter from somebody at Habitat for Humanity who said that Mr. Fleming brought kindness, talent, and humor to the work site. And what I would say about that, Your Honor, is that this speaks volumes about Mr. Fleming, because if you're able to bring kindness and talent and humor to others during the worst period of your life, that's something else. I would just submit to you, Your Honor, that these letters, as a whole, collectively, they're remarkable. And I told Judge Gergel this, and I'll tell you, Mr. Fleming's never read these letters. And I didn't know these stories about Mr. Fleming until I read the letters, because he'd never told me about some of these relationships or some of the people that he'd helped through these things. But he's never read the letters because, it's very difficult for him to think about the fact of how many people he's disappointed in this case. But what we do know, Your Honor, what I know and what his family and friends know is that at the heart of this, he's a good person who made some very bad decisions. And we know that. We know from our experience that good people do make bad decisions. But I would submit to you, Your Honor, that we are all better than the worst thing that we've ever done. And I want to say for a minute, Mr. Bland mentioned the Georgia bar and the very beginning of this process. And what Your Honor is probably aware of, having been a prosecutor, having been in this system for a long time, Mr. Fleming's not unlike 99.9% of the people that I've seen over 30 years in these situations, and he didn't fully come to terms with what he had done immediately. He admitted to some ethical violations, but he did not admit to his criminal conduct initially. But, you know, he made a decision, and it was a decision made this year, to hold himself fully accountable for his actions. And simply because, not because as Mr. Bamberg put, the feds came and knocking. Mr. Fleming's been aware since the very beginning of this that this was a joint federal and state investigation. So it's always been, the feds have always been involved. There was never any surprise there. But he decided, Your Honor, that he was going to cooperate and he was going to plead guilty. And he wasn't made any promises. He didn't receive any deals. There's no deal. You know, he pled guilty in federal court, and his sentence was calculated by the sentencing guidelines. Like I said, it included both the Satterfield and the Pinckney matters, and Judge Gergel sentenced him pursuant to those guidelines. There was no variance, there was no downward departure, there was no stipulation of a sentence. He took the sentence that was within the guideline range, and he didn't know what that guideline range would be when he pled guilty, and he had no idea what would happen or transpire in state court. But at the end of the day, he made a decision to have faith in this system and to expect, like has been his experience and his wife's experience in the judicial system for a long time, that he would be treated fairly. And that's all he's asked for, Your Honor. That's all he asked for today. I would submit to you that he has accepted responsibility for his conduct. He did not put either the state or the federal government through lengthy litigation or a trial. We didn't come here today to quabble about a trial date. We came here today to fully acknowledge the illegal conduct to which he engaged. I know that I've provided Your Honor with a transcript from his federal plea. I think it's very, very clear in that proceeding, in addition to this proceeding, that he has acknowledged his illegal conduct. And not only that, that he is deeply remorseful for his actions. And he appreciates the fact that his actions have impacted innocent people. And that's the reason he pled guilty. And I will say, he is extraordinarily grateful to the Pinckneys and to the Satterfields for their grace. You know, during the federal sentencing hearing, they said they forgave him. They said that again today. That's hugely meaningful to him. And I don't think they'll ever understand how meaningful that is. So we appreciate that, and we appreciate the gracious manner in which they've handled this. So, Your Honor, I would say that Mr. Fleming has suffered, and he has paid a very, very dear price in this proceeding and in the other federal proceeding that would discourage him from ever engaging in similar conduct. And I strongly believe that Mr. Fleming will serve one day as a very important person who can share his story with other lawyers as a cautionary tale, with just other people. And that in and of itself, Your Honor, will promote deterrence. I believe that the tremendous consequences that he has felt in his professional life, he has voluntarily submitted his resignations to the bar of South Carolina and of Georgia. He will never practice law again. And, you know, that is, it was a profession that, although he made some profound mistakes in, it was a profession for a long time that he loved. And so that itself is a tremendous consequence of his misconduct. Also, Your Honor, I can't not let it be said that the notoriety that has surrounded this case and the publicity that has surrounded it has itself, will serve as a significant general deterrence, but it is not something that every defendant has to deal with. It has been quite, as Your Honor well knows, quite significant. Your Honor, I have some people that would like to address the court, if the court would listen to them. And I would like to call them up now, if that is acceptable to Your Honor. And then Mr. Fleming also has some remarks that he would like to make to the court.
All right, we're going to break for lunch now for 1 hour and 15 minutes. It puts us about, what's that, 2:45, I guess it'll be 2:45. So we'll be in recess, 1 hour and 15 minutes.